to all, no? So free access to the courts, that means that there is no payment. That's why when you file a case in the LRC, there is no filing fee, because access to the courts and the quasi-judicial bodies should not be expensive. All persons shall have the right to a speedy disposition. You know, when the Labor Code was promulgated in 1974, one of the objective of the authors of the Labor Code was really speed in the disposition of cases, because they were disgruntled with the Court of Industrial Relations. Prior to 1974, when there was no NLRC yet, we had the Court of Industrial Relations. And the law then was Republic Act 875, which was the Industrial Peace Act since 1953. And that's why you always come across in the labor code the term labor dispute or industrial dispute. Well, technically, there is a difference between a labor dispute and an industrial dispute, because there are labor disputes that are not industrial disputes. No? For instance, a dispute between one union against another union, that's a labor dispute, but that is not an industrial dispute. Why? Because management is not involved. When there is involvement of management, say, for instance, illegal dismissal or unfair labor practice, it is an industrial dispute. When you talk of industry, you talk of the capitalist and the labor. There are people in the waiting room waiting to be accepted. Please accept them. No? And no person, again, that is the prime duty of the government. And then when you go to the labor code of the Philippines, there is a statement in the labor code that says that the technical rules are not binding. In other words, the rules of court are not strictly enforced. They are only enforced by way of supplement. That is why non-lawyers are allowed to appear before the NLRC, but only when they represent themselves or they represent their organization. To avoid some fixer in the Department of Labor and the NLRC, the non-lawyers should be limited to those who are appearing for themselves if they are a party to the case, or they appear in behalf of their organization, a union, or a management. An HR manager who is not a lawyer can appear for management there because non-lawyer, the labor arbiter and the NLRC, and also before the other tribunals like the NCMB, the regional office. No? So the most important document that I will show to you today is this document, which is found in my textbook. No? And to those who are going to take the bar, I will classify 4 kinds of cases. That's why they are color-coded. The green, the pink, the blue, and the yellow. And I will explain each one of them. No? And this will tell you that there are always 4 levels of adjudication. No, from the hearing officer to the appellate body, then to the Court of Appeals, the Supreme Court. No? when the labor code was promulgated in 1974, there was a provision that says that all decisions should be final and executory. The original version of the labor code in 1974 says that the decision of the arbiter is final and executory, and so there was no appeal. But the Supreme Court, in a series of cases, led by the case of Yang Lai versus Executive Secretary and San Miguel Corporation versus NLRC, where the Supreme Court said that under the principle of judicial review, which is embedded and inherent in the judicial department, the Supreme Court cannot be deprived. Take note of this, The Supreme Court cannot be deprived of its power to review, revise, reverse, modify, alter, and even annul decisions of lower courts or administrative bodies performing quasi-judicial functions. And so, even if Congress will pass a law that says that the decision of the arbiter is final or the decision of the voluntary arbitrator is final, that cannot override the more compelling principle of judicial review. In other words, there will always be an interference by the Supreme Court. But since the Supreme Court does not want to admit direct recourse, and because of the principle of hierarchy of courts, which was highlighted in the case of St. Martin Funeral and in the case of National Federation of Labor versus Laguisma, and recently, last year, by the case of Guagua National Colleges versus Court of Appeals, the Supreme Court reiterated the principle that no, Congress, you cannot deprive the legislative. The legislative cannot deprive the judiciary because the power of review is part of the principle of check and balance to make sure that all decisions stay within the bounds of the law and the bounds of jurisdiction. So the Supreme Court cannot be deprived of that inherent power, even if it's not stated explicitly in the Constitution. It is inherent. If the state has the police power inherent in it, the courts, the judiciary has the inherent judicial review authority. So never ever should any law be allowed that will deprive the Supreme Court of that power to review, revise, reverse, modify, alter, and even abrogate or annul any decision of lower courts. So I do not believe that the Supreme Court is the weakest of the three departments. There are people who say that as between the legislative and the judiciary, the judiciary does not have the force. In other words, hindi niya hawak ang pera. Wala din siyang arm because it belongs to the executive, being the commander-in-chief of the armed forces. But the Supreme Court can annul acts of the executive at many times. The Supreme Court has exercised its power to declare as null and void actions of the executive. That's why the anti-terror law is now being reviewed. More than 37 petitions pending before the Supreme Court. And they are now in a quandary. That's why they are not hurrying up, because it's very difficult to say that the law that was passed upon the prodding of President Duterte would be annulled, no? And 12 of the 15 justices were appointed by President Duterte, and they are now given the historic opportunity to either annul or modify or delete some of the provisions, especially those that allowed arrest without warrant and those that allows detention beyond the hours allowed by the revised penal code. Okay, so I mentioned that only to emphasize that the court is also very powerful. No? So I will now classify the cases, kasi many of you will be asking, nakakalito naman itong Department of Labor, sa dami-daming mga opisina sa Department of Labor. We are confused. We are confused, bewildered, and bewitched. Where do we file these cases? Now, for those kayong mga UE, be prepared. I will ask you in the finals, where will you file the following cases? No? So we will start with Class A. No? If you look at this graph, Class A are the green one. Why do I consider it as Class A? Because under the Constitution, in Article 13, Section 3, the third paragraph of Section 3 of Article 13 expresses preference for voluntary modes of dispute settlement. So, the Constitution tells us, both labor and management, do not use the NLRC. Do not go to the labor arbiter, because that is compulsory arbitration. You are encouraged to go to voluntary arbitration. Now, but in real life, if you have a union and you have a collective bargaining agreement, one of the required provisions of the collective bargaining agreement procedure. In other words, your CBA will not be registered by DOLE if they will see that you do not have a provision for grievance machinery. That is a compulsory provision. That is a required provision. So why do we need a grievance procedure? And this is Class A. Because if there is a conflict on the interpretation and implementation of the CBA, where should you bring it? You cannot bring it to the labor arbiter. You cannot bring it to the regional director. You cannot bring it to SSS. You cannot bring it to POAA. Because there must be exhaustion of internal remedies. And this is an internal remedy where both parties, the union and the management, are given the first crack, the first opportunity to solve their own problem. And this is the very essence of free collective bargaining. Because the state should not interfere if the dispute, for instance, is about salary increase or it's about the giving of a benefit arising from the CBA, not arising from law. And you are you are now debating how to implement it because the wording of the CBA is ambiguous. So you go to the grievance machinery. And so you will ask, sir, if we do not have a union, we do not have a CBA. And we do not have a CBA, we do not have a grievance procedure. So we have nothing to bring to the grievance machinery. Is that statement correct? The answer is no. You still have a grievance because enforcement of company policy that are related to personnel. So if you have a problem in enforcing your company policy, for instance, you have a policy on work from home, no? Policy about work from home. Because we are in a pandemic situation and certain employees are questioning the wage and salary system during work from home. They ask whether or not those who are working from home are entitled to overtime pay. Well, that belongs to the grievance machinery because it is interpretation, enforcement of company rules and regulation on discipline, including personnel. No, personnel. The wording of the law does not mention discipline, but personnel. So personnel, company policy, company personnel policy. No, company personnel policy, and these are the provisions that I have enumerated in as Class A. No, and there is a third dispute here, and you will be surprised because the law says all other disputes, all other disputes, even if they belong to the NLRC, if the parties will agree, that should be brought to grievance and voluntary arbitration. It can go direct to voluntary arbitration if it is all other disputes. For instance, all other disputes including unfair labor practice and deadlock in collective bargaining. You can bring it directly to voluntary arbitration because voluntary arbitration is the preferred mode. It is preferred than the compulsory arbitration. Now, for the students, when we mention compulsory arbitration, that refers to the NLRC, the labor arbiter. The labor arbiters are the compulsory arbitrators. The voluntary arbitrators, like myself, I am a voluntary arbitrator. We are private citizens accredited by the government, licensed to hear and decide labor disputes based on the submission agreement. The parties cannot agree. So they go to the NCMB, and the NCMB will conciliate and mediate, and still they could not agree. So they are now going to submit this case to voluntary arbitration. And there is a list of voluntary arbitrators. The parties will choose from this list. If they are in disagreement, they can draw by lot. And once the name of the voluntary arbitrator is chosen, he will be called. Just like this morning, I was called, will you accept a case? No? And I said, yes, I accept. Then they will submit to me the submission agreement. It is like a contract signed by the parties that we agree to submit our case to former Undersecretary JBJ. We will respect his decision. No? If there is no grave abuse of discretion, we will implement the decision. We will accept it. No? and we are going to pay the arbitration fee. Now, for the union who cannot pay, there is a budget by government to subsidize those who cannot afford. But management will not be subsidized, only the union. No? So type A cases are classified into three. One is CBA, related interpretation and implementation. Second is company personnel policies. And the third, this is very wide, all other disputes by agreement of the parties. Now, even if the case is already pending before the labor arbiter, if the parties will say, Your Honor, Mr. Arbiter, the complainant and the respondent have agreed to withdraw this case from compulsory arbitration, and we will go to voluntary arbitration by agreement. That is allowed by law. That is an exception to the rule that jurisdiction is determined by law, not decided by the parties. Here in labor cases, the parties are given the discretion to bring it to voluntary arbitration. But the reverse is not allowed. From voluntary arbitrator, you cannot bring it to compulsory arbitrator. No. So why is it that 98% of the cases still go to voluntary arbitration? Because voluntary arbitration is without any payment to the arbitrator. The arbiter receives salary equal to RTC judge. But the arbitrator is not a government employee. So he has to be paid for his effort of studying the case, deciding the case. And if he is ordered by the Court of Appeals to submit all the documents, then he has to abide until the case is executed, no, by when the judgment becomes final and executory. So grievance machinery is allowed only 7 calendar days. Can you imagine? There is a sense of urgency. The grievance machinery must be able to resolve the dispute within 7 calendar days. Now, what happens if they cannot? Then they are directed to bring it to voluntary arbitration. 7 calendar days is a very short span of time. It's not working days, it's calendar days. And I don't think that the grievance machinery can do that, because grievance machinery is composed of equal representation. 3 from management, 3 from labor, 6 of them. So they will reach a deadlock because management would insist on its position and labor would also insist, and they cannot arrive. They need a third party, the voluntary arbitrator, who will resolve the deadlock, who will stop the impasse between the two and provide a solution. And of course, the decision of the voluntary arbitrator used to be appealed directly to the Supreme Court. I have many cases that I decided that were, even when I was with San Miguel Corporation, Pepsi Cola, I was already an arbitrator. Before I became undersecretary, I was an arbitrator. So many of my cases were appealed direct to the Supreme Court. There was no Court of Appeals before. The Court of Appeals were limited to criminal, civil, tax, and others. But because of the case of Loon Development Bank, and I will discuss this later, which was ahead of St. Martin funeral. No? Take note, those who will take the bar. Because of the case of Loon Development Bank, the decision of the arbitrator should be brought to the Court of Appeals by 65-43 certiorari. And there is only 15 days. 15 days. So, going back, grievance machinery, 7 calendar days. Within 7 calendar days, bring it to voluntary arbitrator. If you lose before the arbitrator, you file a motion for reconsideration because that is part of exhaustion of administrative remedies. You cannot just go to the Court of Appeals without exhausting the administrative remedies. So, once your motion for reconsideration is denied, you have 15 days. So, ang tanong, sir, within what time can we file the motion for reconsideration? The answer is 10. 10 days after you receive an adverse decision by the voluntary arbitrator, you have 10 days to file an MR. And if your MR is denied, you go to the Court of Appeals by Rule 43, and you have 15 days to do that. So all in all, 25 days. Okay? So that is the classification A. Now, let us go to classification B, which is 95 to 98% of the cases are now compulsory arbitration. Although preferred ang classification A, punta pa rin ang mga tao sa less preferred. No? So, ano-ano yung mga kaso sa classification B? Ito yun, which is enumerated in Article 224 of the Labor Code. Unfair labor practice, kung ayaw mo magwelga, ayaw mo mag-strike, so mag-file ka ng kaso. Kasi pwede ka namang mag-file ng notice of strike pag may ULP. Pero ayaw mo mag-strike, mag-file ka na lang ng case, labor arbiter. Termination disputes includes illegal dismissal, constructive dismissal, illegal demotion, illegal transfer, no? All violations of security of tenure are fall within the classification of termination disputes. Now, money claims with a claim for reinstatement. If you file a money claim, even if for 100 pesos only, if you accompany that claim with a prayer for reinstatement, that becomes a termination dispute because reinstatement is the remedy for termination. So kung haluan mo ng reinstatement yung money claim mo kahit ang amount is less than 5,000, labor arbiter talaga yan. But remember that all of this can be brought to voluntary arbitration by agreement of the parties. Yun lang ang problema kasi if only one party will say, I bring it, it will not come about. No? Only the CBA and the company personnel policy na walang choice ang parties, it should be with the grievance machinery and the voluntary arbitrator. Then, if you file an actual damages, moral damages, exemplary damages, doon yan sa labor arbiter. And then, when you, if you are management and you want the strike to be declared illegal because you want the illegal strikers to lose their employment, you go to the arbiter and you ask the arbiter to declare the strike illegal. This was done in the case of Hong Kong and Shanghai Bank versus NLRC. And the ponente was Justice Lucas Bersamin before he was Chief Justice. So legality of strike or lockout, no? If it is the company who closed the company without notice, no, and the employee is alleging illegal lockout, labor arbiter. And then pure money claims without claim for instatement if it exceeds 5,000. If it is exactly 5,000, it can be brought to the regional director if it does not have a prayer for its statement. So going back to this, no? The blue, the pink one, labor arbiter, formerly to Article 217 is now Article 224. Now, the jurisdiction that I enumerated, you should add Migrant Workers Act, the claim filed by the OFW. When the OFW is not paid their salary in the other country by the foreign principal, and he comes home empty-handed, he files a case against not the foreign employer, because we cannot acquire jurisdiction over the person of a foreign employer, but against the recruitment agency. And the recruitment agency will be held liable for all the damages caused by the act or the omission of the principal by virtue of the Magna Carta of Overseas Workers as amended by Republic Act 10022. So from the labor arbiter, if you lose before the arbiter, you do not file a motion for reconsideration. Mali. Just like in the grievance machinery, you cannot file a motion for reconsideration. You go direct to the NLRC from the arbiter. And it is when the NLRC decides against you, no, that you file an MR. How many days from the arbiter to the NLRC? 10 calendar days. 10 calendar days. No motion for reconsideration. Once the NLRC decides the case, resolves the case, and you still lose there in the NLRC, you have to file an MR within 10 calendar days. And if the MR is denied to the Court of Appeals, what is the rule? Rule 65. Sa voluntary arbitrator, Rule 43. Sa NLRC, Rule 65. How many days? 60 days. Mahaba. Now, from the Court of Appeals, whether that case comes from the arbitrator or the NLRC, and the Court of Appeals still decides against you, you have to file an MR within 10 days. If you still lose in the MR, you go to the Supreme Court. How many days? Anong rule? Rule 45. How many days? 15 days only. So you have to memorize. What are the grounds for appealing the decision of the arbiter? to the NLRC, there are 4 grounds. First, grave abuse of discretion. No? Second, serious errors in the findings of facts, which, if not corrected, will cause grave and irreparable damage. No? Third, pure questions of law. And fourth, graft and corruption. Nobody would like to use the fourth ground, but for purposes of the bar exam, you know what are the grounds. The grounds from the NLRC to the Court of Appeals is grave abuse of discretion. The ground from the Court of Appeals to the Supreme Court, pure questions of law. The Supreme Court will not entertain questions of facts because the findings of facts of the labor tribunals as well as the Court of Appeals are respected by the Supreme Court as binding. And therefore, if you bring a case to the Supreme Court because of factual issue, that petition would be denied under Rule 45. Okay, so what is the Class C cases? Well, the yellow one, the regional director visitorial power under Article 128. Here comes the inspector going to the factory. And the inspector makes a finding that the company is engaged in labor-only contracting, that the contractor does not have sufficient capital, or the activity that is contracted out is directly related to the principal business of the employer. And also the inspector can say that there is a violation of general labor standards, meaning wrong computation of overtime pay, night difference, service incentive leave, 13th month pay, all this in Book 3 by virtue of the visitorial power under Article 128. The inspector makes a report, and then the regional director, who may not be a lawyer, will adopt the report of the inspector and then makes an order. The order is like a decision. And when you receive the order from the regional director, you cannot file an MR. You cannot file a motion for consideration before the regional director. You have to go to the Secretary of Labor, appeal. That's why there are many cases pending in the office of the Secretary, because even the next kind of cases, the intra-union certification election cases, may protesta, will be brought to the Secretary. Yung mga OFW cases sa POAA, halimbawa, nagalit yung employer, the employer was angry at the OFW because the OFW signed a contract for 2 years. And then he did not honor the contract. He transferred to another employer. So the employer now gets back at the employee through the agency, asking the POAA to ban this OFW from going to this country. That can be allowed, no? That is an administrative offense, and that is heard by the POAA. The POAA should also be here, but I have no more space for the POAA. And the POAA decision goes to the Secretary of Labor. That's why once the Secretary of Labor makes a decision and that is adverse to you, you have to file an MR because of the principle of exhaustion of administrative remedies. Within 10 days, file an MR. Now, if the MR is denied, go to the Court of Appeals. Rule 65, just like the NLRC, Rule 65. Within how many days? It is 60 days. What is the ground? Grave abuse of discretion amounting to lack of jurisdiction. Okay, so there are other cases like I classification D. No? The other part of Class C is Article 109, 129, which is pure money claims. No? Pero ang pure money claims, if we go back here, Article 129 belongs to the pink because this will be appealed not to the Secretary of Labor, but to the NLRC. And take note, only 5 days. The appeal is only 5 days. Because that is a pure money claims not exceeding 5,000 pesos without a prayer for reinstatement. There is a sense of urgency. Patagalin mo pa ba yung, ang hiningi lang niya 5,000 pesos? In fact, this amount should be adjusted already. Just like the revised penal code, dati meron diyang fine na 200 pesos, binago na because of the value of the money. Okay, so going to Class D. Class D. If you remember intra-union dispute and inter-union dispute. Ano-ano ba itong mga kaso na ito? No? Yung mga itong Class D. Pag nag-aaway yung mga walang kinalaman dito ang employer. Ang pinag-awayan lang dalawa, pera at saka power. No? Pag aaway sila ng union fund, mga illegal deduction, kung ano, merong mga increase of union dues without being ratified by the general membership, they want to impeach the president, or they want to expel some union members for disloyalty. Those are intra-union dispute. Inter, pag ang kalaban natin, Union A versus Union B, certification election, that is an inter-union dispute. And that belongs to classification D. Nasaan yung classification D? No? Nandito nasama dito sa yellow. Kasi nasa kuan yan, med arbiter. Med arbiter, Secretary of Labor, Court of Appeal, Supreme Court. No? Dapat ibang kulay yan. No? Then the classification E. Yung is claim dito, yung blue. When you ask for benefits, disability benefits, like death benefits, disability benefits, sickness benefits, under Book 4, file it with SSS. If you are in government, file it with GSIS. If denied, then go to the Employees Compensation Commission, which is chaired by the Secretary of Labor, and he delegates it to the Undersecretary. I was chairman of this commission for 3 years. And the job of this commission is, number 1, to review the list of diseases that are considered compensable and to update. Because when you say, when you claim for death benefits arising from disease, the first thing you will do is look at the list. Was the cause of the death included in the list? If it is not, do not despair, because you can present an expert witness, a doctor, who will connect the causal relationship between the nature of your work and the cause of your death. That requires a medical testimony. No? And so, you bring it to SSS, but you were denied, you go to ECC. The first job of ECC is to review. The second job of the ECC is to review the appealed cases. Yung mga denied ng SSS, nag-a-appeal, doon dadalhin yan sa ECC. And the ECC chaired by the government, merong representatives of labor, there are 2. Representative of management, there are 2. And representative of SSS and GSIS. Plus Department of Health. Because this is pertaining to medical matter. For instance, the question will be asked, is death due to COVID compensable? No? If you are asked this question, employee A died, diagnosis of the doctor, cause of death, COVID. The spouse, the surviving spouse filed a claim for death benefits. Will you grant or deny the claim? The answer is it depends. Because since it is not listed, I have to present evidence that because of his work, and there were employees who were carriers, asymptomatic carriers, and it is proven that he contacted that disease inside the company, then it can be granted because it is work related. It arose out of his employment. So it is not automatic. You cannot say automatic yes, no. But anyway, the other kinds of cases under classification A are POAA cases, the one I told you, and also the RTWPC, PB. Ano yan? Regional Tripartite Wage and Productivity Board. If you are a company, a small company, and you cannot afford the minimum wage, you are a micro enterprise, you are registered by DTI as micro enterprise. You go to this Regional Tripartite Wage and Productivity Board, you ask for exemption from the coverage of the minimum wage. Now, if your petition is denied, where do you appeal? No? Then you appeal to the National Wage and Productivity Commission, which is chaired by the Secretary of Labor. And then from that commission to the Court of Appeals, then to the Supreme Court. See, it's very easy. And at this point in time, no, I will go to the cases. No? You should, those who are going to take the bar, you should be familiar with Rule 65 because you use Rule 65 when you lost before the NLRC, you lost before the Secretary of Labor, you lost before the Employees Compensation Commission. No? But if you lost before the voluntary arbitrator, you use Rule 43. Now, if you lost before the Court of Appeals, after you filed an MR, it was still denied, you use Rule 45. No? So that is very easy. Now, we will now go to the case of St. Martin Funeral Homes. Bakit mahalaga itong kasong ito? Mahalaga ito kasi ginambala ng Supreme Court na gimbal ang ating labor adjudication system because of this case. And this started with a very simple case in Pampanga, San Fernando, Pampanga, na merong isang tao na si Benvenido Aricayos na tiyuhin ng may-ari ng funeral parlor na habang naghihintay pa siya ng makapunta sa abroad, pinabantay muna siya ng mga bilihan ng ataol. No? So, while he was waiting, no, he is given some allowances, but mga relative ito. Parang wala talagang formal discussion that there is employer-employer relationship. Now, there was an amount of 38,000 pesos that was lost. And this money was supposed to be paid to the BIR for the taxes. And when the daughter looked at the records, it remained unpaid. And so they blamed the uncle Benvenido Aricayos and blame him for pocketing the 38,000 pesos. And because of that, he was no longer allowed to come to the funeral homes. And because of that, Aricayos filed a case. The labor arbiter, believing on the defense of management, declared that there was no employer-employer relationship. So the case is dismissed. But Aricayos went to the NLRC. But the NLRC said, there is employer-employer relationship because the elements are present. There is payment of compensation. He was allowed to work. No? There was a meeting of the minds. Even if there is no written contract. Written contract is not necessary. No? Because this is a consensual contract. Now, since the management lost before the NLRC and their MR, they filed an MR and the MR was denied, so management went to the Supreme Court. Because at that time, I told you, Court of Appeals was not part. The Court of Appeals were never a part of labor dispute settlement. It was always from NLRC to Supreme Court, from voluntary arbitrator direct to the Supreme Court, from Secretary of Labor direct to the Supreme Court, from employees' compensation direct to the Supreme Court. But because of this, and this case was decided by the lawyer who got the highest grade in the bar examination, never surpassed, not even by Ferdinand Marcos, Florence Regalado, former Dean of San Beda, and one of the most brilliant legal minds we ever had, but he never became a Chief Justice. And this is where the Supreme Court said, we will not decide on the merit of the case first. We have to discuss the procedure. No? And he said that before there was a law that the decision of the arbiter and the NLRC are final. But you have to remember the principle of judicial review. You cannot bypass the Supreme Court. You cannot make your decision final and deprive the Supreme Court of its inherent power to review. So, mali yung ginawa nyo. Bakit ka dumiritso sa akin? Because tama yung pumunta kay sa akin, but you have to go to the Court of Appeals because of the principle of hierarchy of courts. No? And then in this case, the Supreme Court very patiently discussed the history, including the Judiciary Reorganization Act of 1980, Batas Pambansa 129. The remedy of appeal from the decision of the NLRC to the Secretary of Labor. Can you imagine? During martial law, galing sa NLRC tripartite. Ayan. Merong government, may labor, may management. Tatlong komisyoner appeal. Martial law, the strongest department is the executive department. The country was governed by the constitutional dictator, the constitutional aristocrat, by virtue of his authority as the commander-in-chief of the armed forces of the Philippines, pursuant to Proclamation 1081. And he wanted that all cases should pass through the office of the president. That's why from the office of secretary, it goes to Malacanang. Executive Secretary, who is now Ronaldo Zamora, who is bar top notcher number 1. So, can you imagine from labor arbiter to the NLRC, number 2, number 3, to the Secretary of Labor, then number 4, office of the president. Then, they believe that that is the end because it was martial law. But came the case of Yang Lai versus Secretary of Labor, where the Supreme Court said, no, that is not final, because those who will lose the case in Malacanang can go to the decision of Malacanang, of the office of the president, because of the principle of judicial review. That is why Justice Florence Regalado had to discuss judicial review. And he said here that you cannot eliminate judicial review because that is an intrinsic component of check and balances, which is embedded in the core foundation of our democratic system. So, lalo nang humaba ito. The court is therefore of the considered opinion. Mr. Carion, can you read that, Mr. Carion?
Yes, USEC. The court is therefore of the considered opinion that ever since appeals from the NLRC to the Supreme Court were eliminated, the legislative intendment was that the special civil action of certiorari was and still is the proper vehicle of judicial review of decisions of the NLRC. The use of the word appeal in relation thereto and in instances we have noted could have been a lapsus plume because appeals by certiorari and the original action for certiorari are modes of judicial review addressed to the appellate courts.
Sige, tuloy mo.
Okay, sir. There is a growing number of labor cases elevated to this court, Supreme Court rather, which, not being a trier of facts, has at times been constrained to remand the case to the NLRC for resolution of unclear or ambiguous factual findings that the Court of Appeals is procedurally equipped for that purpose, aside from the increased number of its component divisions, and that there is undeniably an imperative need for expeditious action on labor cases as a major aspect of constitutional protection to labor.
One of the important pronouncement here is that the last portion, expeditious action on labor cases is a major aspect of constitutional protection to labor. Meaning, when you delay the case, you violate the principle of constitutional protection to labor. Delaying a case will always be anti-labor because management may benefit out of a delay, or in fact, management may be the cause of the delay. So the state, if it is faithful to its mandate to protect labor, must expedite. The word is expedite. Bakit ang ginamit na word expedite, hindi sinabing fast? I'll tell you, Mr. Carion, you can be fast and yet you are not expeditious. You know, in San Carlos, there was formerly a dean in the College of Law by the name of Expedito Bugarin. He was a practicing lawyer. I was a court interpreter. And he was a brilliant lawyer, Expedito Bugarin. Yan ang pumalit kay Paul Bupilis na pinalitan naman siya ni Gabi Ingles na nagiging Court of Appeals Justice. Now, yung word na expeditious, you can be fast but not expeditious. I'll tell you, when I was a labor arbiter, there was a case filed by the taxi drivers in Cebu against the taxi operator for collection of 13-month pay and other benefits. And the counsel for the management, instead of filing a responsive pleading, which is the position paper, filed a motion to dismiss. Now, take note. If I am a fast arbiter, I will resolve the motion. I'll say the motion is denied. But if I do that, once I deny the motion, they can now appeal. So, hindi ko pa na-resolve yung merit ng kaso. Ni-resolve ko yung motion to dismiss and the management will elevate that to the NLRC. It will take how many years? From the NLRC to the office of the secretary, from the office of secretary to Malacanang, then to the Supreme Court. By that time, babalik yung kaso sa akin for hearing on the merits. Is already patay na lahat ng driver. So, I am not fast, but I'm expeditious. When there is a motion to dismiss, that is an interlocutory motion. Remember the words interlocutory motion. And I should not resolve an interlocutory motion. I will just say noted. Your motion is noted. When I resolve the substantive issue of the case, I will rule on the motion. And I will consider that as one of the issues submitted for resolution. That is expeditious. Because to be expeditious is not necessarily to be fast. Pareho na sa giingon, parang sinabi na, kung nagmamadali ka, dahan-dahan. Kung nagmadali ka, inday, pag hinay-hinay ka. Kung mapandol ka, lawom imong samad. No? Kaya kayong kukuha ng bar, magmamadali kayo masyado kasi na kuhan kayo, na pressure kayo. Maya, marami kayong nakakalimutan. Marami kayong nakakaligtaan. So, you should be expeditious, not necessarily fast. No? Because fast, sa pagdinali mo, nagkadisgrasya ka pag-drive, na-delay ka na. Hindi ka na makarating. No? So, ang sabi ng tigulang, kung magdali ka, inday, pag hinay-hinay. Yan. Ibig sabihin, magdahan-dahan ka sa iyong pagmamadali. No? So, Mr. Jico Medina, can you read this?
Yes, sir.
Hmm.
St. Martin Funeral Home versus NLRC proposed to this directive that restore the higher courts should be made in accordance with their hierarchical order. This pronouncement in Santiago versus Vasquez, etc., should be taken into account. One final observation, we discern in the proceeding in this case a propensity on the part of the petitioner, and for that matter, the same may be said of a number of litigants who initiate recourses before us to disregard the hierarchy of courts in our judicial system by seeking relief directly from this court, despite the fact that the same is available in the lower courts in the exercise of their original or concurrent jurisdiction, or is even mandated by law to be sought therein. This practice must be stopped, not only because of the imposition upon the precious time of this court, but also because of the inevitable and resultant delay, intended or otherwise, in the adjudication of the case, which often has to be remanded or referred to the lower court as the proper forum under the rules of procedure, or as better equipped to resolve the issue, since this court is not a trier of fact.
Okay. So, Mr. Batong Bakal, can you read that?
Sir, we therefore reiterate the judicial policy that this court will not entertain directly resort to it unless the redress desired cannot be obtained in the appropriate courts or where exceptional and compelling circumstances justify availment of a remedy within and calling for the exercise of our primary jurisdiction.
Okay, so ladies and gentlemen, this case of St. Martin Funeral has changed our system of adjudication, because whereas before it was only 3 levels, from NLRC, from labor arbiter, NLRC, Supreme Court, grievance, voluntary arbitrator, Supreme Court. Now we have 4 levels because the Court of Appeals has been inserted because of this doctrine of hierarchy of courts. No? Hierarchy of courts. So the Supreme Court was saying, you cannot bypass us, but you cannot come to us directly. You have to go to the Court of Appeals first because we do not want to review the factual. If the facts are vague or ambiguous, we are the Supreme Court. We do not have time for factual thing. We are only here for questions of law, for constitutional issues. We do not waste our time for issues about facts. No? Kung ikaw ba ay nanuntok ka ng kapwa mo empleyado, o kung ikaw nangupit ka ba sa kumpanya, those are factual issue that should be finally decided by the Court of Appeals reviewing the NLRC and the labor arbiter. But the Supreme Court will not go into that details. The Supreme Court will limit itself on questions of law under Rule 45. So that is really the importance of St. Martin Funeral. And these are all the justices that signed or concord. There was no dissenting opinion. All of them, all of them agreed to the decision of Justice Florence Regalado. So we go to the Development Bank of the Philippines. I will not bore you with the details. I just tell you the bottom line. If the St. Martin Funeral is about the NLRC and the labor arbiter, Luzon Development Bank is about voluntary arbitrator. So yung voluntary arbitrator noon, from voluntary arbitrator direct to the Supreme Court. Now, no. You have to go through the Court of Appeals. And that is, nauna pa nga itong Development Bank of Luzon Development Bank. Nauna pa ito kaysa St. Martin Funeral. Kasi 1998 yung St. Martin. Ito 1995. So, this case was decided by a lady justice, professor of UP, School of Labor Law, expert of labor law, Florida Roth Romero. She was also a voluntary arbitrator. And these are all the justices that agreed with her decision, including the Chief Justice, but he was on leave. And the third case is National Federation of Labor. Now, National Federation of Labor is about the Secretary of Labor because this case is about an intra-union dispute. Now, attention Cebu students. This is about the case of Cebu Shipyard and Engineering Work. No? You know, when you were not yet born, all of you, including Dean Wagas. Dean Wagas, you were not yet born. When itong kinatitirikan ng mga building dyan sa reclaimed area from Cebu City, from Plaza Independencia all the way to Mandawi City. These are tubig yan nung araw, dagat yan. And there was an island. An island, ha? Ano yung island na yun? Yun ang shipyard na pag-aari ng isang tao na ang pangalan si Mr. Ponce. Si Mr. Ponce ay supporter ni Ramon Durano, which was the mortal enemy of Sergio Osmeña Jr. So since Sergio Osmeña Jr. was the kingpin of Cebu City and Ramon Durano was the kingpin of Danao, para silang langis at tubig, they were mortal enemies, no? And itong si Ponce who owned the shipyard had an island. Ang lahat ng mga barko, all the vessels that required repairs, dadalhin diyan sa Ponce Island. And nung nag-reclaim si Sering Osmeña, ni-reclaim niya yon, ginawang lupa. Ginawang lupa, yung island niya nagiging lupa na. Wala na, hindi na siya makanegosyo ng shipyard because tinamaan siya ng reclamation eh. But this is just a side story, no? When this was still existing, no, maybe it was transferred to another location, there was a certification election. Actually, the existing union was the NFL, National Federation of Labor, nagkahiusang mamumuo sa Baradero, no? Sa mga Tagalog, ibig sabihin nagkakaisang mga manggagawa sa shipyard, no? Now, when the CBA was about to expire, during the freedom period, another union, the KMU, Anglo KMU, entered, filed a petition for certification election. Okay. The main arbiter in Cebu denied the petition, dismissed the petition. What is the ground? You have not been organized as a legitimate labor organization. How can you file a petition? You have no juridical personality. Hindi pa allowed ang federasyon noon to file in behalf of the local. The local should organize themselves as a legitimate. So, denied ka. Now, so the union, the KMU, appealed to the office of the secretary. And under Secretary Benvenido Laguisma at that time, under secretary, the secretary was Nieves Confisor, the first female secretary of labor, but she was not a lawyer. So Laguisma, who was an Ateneo lawyer, was the undersecretary. He was authorized to decide the case. And he decided in favor of KMU and said that it is not correct to say that the local was not organized. It was organized and it has the juridical personality. So the Secretary of Labor, the Undersecretary, Laguisma, ordered the holding of certification election to fight the three contenders. One is NFL versus KMU versus no union. But the NFL, which is the incumbent union, went to the Supreme Court, asking the Supreme Court to annul the order of the Secretary of Labor for having been issued with grave abuse of discretion. Now, this is just the same as the Loon Development Bank. The case of St. Martin Funeral pertains to the NLRC. Then NLRC used to be direct to the Supreme Court, should pass through Court of Appeals. The Loon Development Bank, from the arbitrator direct to the Supreme Court, now they are told to go to the Court of Appeals. Here, from the Secretary of Labor, you cannot go direct to the Supreme Court, but you have to go to the Court of Appeals. That's why these three cases, if I were the bar examiner, I will ask this because all the three cases are in bank cases. Ito si Justice Kapunan. Ito ang father-in-law ni Lorna Kapunan. Si Lorna Kapunan, lawyer yan, very, very popular lawyer. No? He ran for senator and she lost. And she is the daughter-in-law of Justice Roberto Kapunan. No? And the Chief Justice, who is from Cebu, concurred with the decision of Justice Kapunan. So our conclusion now for the three cases, number one, you cannot deny the Supreme Court of Judicial Review. Number two, you have to go through the Court of Appeals because of the principle of hierarchy of courts. I hope that you understand all this. So in Guagua, no, the question here is conflict between the labor code and the rules of court. Now, I ask you, no, I will ask you, if there is a conflict between a provision of the law and a provision of the rules of court, which will prevail? Well, maybe you would say it should be the law, no? Because it is a legislative act. The rules of court is a creation of the judiciary. Now, if it involves substantive right, it should be the law that will apply. But here, the law is more detrimental than the rules of court. Anong sinabi ng law? Ang sinabi ng law, the labor code says that from the decision of the voluntary arbitrator, you have only 10 days. If you cannot appeal within 10 days, it becomes final. That is the Supreme Court. The Labor Code says 10 calendar days. When the law says 10 days, it should be calendar days. No? Now, the problem is under Rule 43, it says 15 days. So which will you follow? The 10 days or the 15 days? Now, I don't want to bore you with the details. I'll go to the bottom line. The bottom line says, no, the bottom line, no. Miss Evangelista, are you here? Can you read this? Jerlyn? Wala. Ikaw,
Hello, sir. Good
Miss.
evening po.
Yes.
The landmark decision on reglementary periods in voluntary arbitration. The ruling of the Supreme Court is first. Hence, the 10-day period stated in Article 276 should be understood as the period within which the party adversely affected by the ruling of the voluntary arbitrators or panel of arbitrators may file a motion for consideration. Second, only after the resolution of the motion for reconsideration may the aggrieved party appeal to the Court of Appeals by filing the petition for review under Rule 43 of the Rules of Court within 15 days from notice pursuant to Section 4 of Rule 43. And third, the court notes that despite the clarification made in Teng versus Pagahak, the DOLE and the NCMB have not revised or amended the revised procedural guidelines in the conduct of voluntary arbitration proceedings insofar as its Section 7 of the Rule 7 is concerned. And lastly, this inaction has obviously sown confusion, particularly in regard to the filing of the motion of reconsideration as a condition to the filing of the petition for review in the Court of Appeals.
Okay. So, earlier I was asking you which will prevail, the labor code or the rules of court. The answer to that is that the Supreme Court did not say one is correct, the other is wrong. What the Supreme Court said is to combine the two and say, oh, they are not in conflict. No, you use the 10 days first to file an MR. If your motion for reconsideration is denied, then you use the 15 days to file the Rule 43 petition to the Court of Appeal. So it is now 25 days. No? So I hope that this is clear to you, and for our final sa UE, this will be asked. And since the Sanbeda, we will meet again this coming January, we will further elucidate on that. So because we are still, when we meet, I don't know if we still have a meeting. Miss Jerling, do we have a meeting this coming tomorrow? Tomorrow?
Yes, sir. Still have a meeting po.
Okay, so I will discuss the just causes. We have finished with serious misconduct and subordination. We'll talk about fraud and the others, no? And then when is our last day? Tomorrow or next Wednesday?
Sir, we still have until next week, but it is not yet final, I think. Because
Okay, we have two meetings. I will now take up this case of Ludo Luim Corporation. Now, for the Cebuanos, you are familiar with Ludo Luim. And for UV, you are familiar with Attorney Ferdinand Saornido. No? Because this case was decided by the late Attorney Ferdinand Saornido, who was murdered. No, he was murdered. He was a former security guard who became a lawyer, working student. He was a good lawyer. He was an honest lawyer, and he was assigned this case. This case is a very simple case, but it had very complicated legal issues, and very important one, because this will be a very good question for the bar. The facts of the case is that there were 200 arrastry workers employed by a Chinese businessman by the name of Crescencio Lu, and his firm was called Class, no, which is Crescencio Lu Arrastry Service, no, and they formed a union and they signed a CBA. But they have some money claims, and these money claims were submitted to voluntary arbitrator Ferdinand Saornido for resolution. No? And one of the issues submitted was, the issue was whether or not the employees were regular employees of Ludo or they were employees of Crescencio Lu. So this was submitted by the parties to Ferdinand Saornido, and Saornido decided the case. He decided that the employees, 214, were not employees of Crescencio Lu, but they were employees of Ludo Luim, because Lu was declared as a labor-only contractor. And Attorney Saornido awarded more than 5 million, 5.7 million in money claims, plus 10% attorney's fees, plus interest. No? Ito, si Saornido talaga, nangunguna dyan, because the case of Dario Nacar versus Gallery Frames was decided only in 2015 or 2016 by Justice Diosdado Peralta. But as early as this time, which was 1999, no, Saornido already imposed interest. But the issue that was submitted here in Ludo and Luim, there were 3 issues. I will not bore you with the details, but I will discuss 3 important issues. Number 1 issue is does the voluntary arbitrator have jurisdiction over issues that were not submitted to him for arbitration? Ang sinubmit lang sa kanyang kaso ay ang status of the employees, whether they are regular of Crescencio Lu or Ludo and Luim. That was the only issue. But Saornido also decided the money claims. Now, the question is, can the arbitrator decide a case which was not submitted for resolution? Your answer should be, as a general rule, no. Because the jurisdiction of the arbitrator is limited to what the parties submitted to him. However, as an exception, like this case is an exception, when the other issue is closely intertwined, remember the word intertwined. Kung sa Bisaya pa, nabaliktos. Kasi twine is PC, no? So, nahilambigit, no? That is the correct word. Kung ludabi ka, nahilambigit. Kasabot ka na, Attorney Carion, na when the second issue is closely intertwined with the main issue. No? Kasi kung sabi nila, kung kami, if we are employees of Ludo, then Ludo should pay us the minimum wage because we were not paid properly by Crescencio law. He has to pay us overtime pay, 13-month pay, and all the monetary entitlement that were denied of us. Now the management question sa Ornido before the Court of Appeals, na why did you include the money claims when what was submitted to you was only the issue of employment status? Well, dalawa ang reason ni sa Ornido. One, when the issue is intertwined. What is the meaning of my resolution of the issue of status if there is no benefit? So empty victory, okay, empleyado kayo, then you will need to file again another case. And that will be multiplicity of suit. That will be splitting the cost of action. That will be forum shopping. No? And that those are obnoxious to the orderly administration of justice. And so therefore, Saornido was correct in including the issue of the money claims. Now, another issue which Saornido really enriched the jurisprudence. You should be proud as a Bisayanian that it was a Bisayanian aside from Senator Herrera being a graduate of UB, no, who enriched the labor code. Now, Saornido enriched the jurisprudence. This is the issue of prescription. No? Management said the money claims already prescribed because it is beyond 3 years. Okay. According to Saornido, when do you start counting the 3 years? No. When do you start counting the 3 years? You students listening to me, you should listen to this. Kung hindi ka binayaran noong 2005, ngayon 2020 na. No? And pag kinount mo yung 3 years, lampas na yon. Your case will be dismissed, nag-prescribe na. Pero according to Saornido, you start counting, and the Supreme Court affirmed him, you start counting the 3-year prescriptive period from the day that the company replied to your demand and he said no. When the company replied to your demand, no, as long as your demand was made within the 3-year period, and it took the company so long to reply to your demand. And if the company did not reply, then the prescription will not start to accrue. No? So, do not be afraid na yung claim mo ay masyado na matagal. Kung hindi ka nagpadala ng demand, magpadala ka ng demand, then from that time that the demand is denied, that is the time you start counting the 3-year period. Can you imagine? Sino nakaisip niyan? Si Attorney Saornido. And then after this done 1 year after that decision, he was killed. He was murdered. No? Saornido, to me, is a hero. No? Now, the case of Saornido in Ludo Luim was adopted by Justice Peralta in this case of Goya. Goya was a chocolate before, no? It was a chocolate manufacturing company. And this is a case filed by the union, no? The union won the case and management went to the Supreme Court. And again, the issue is the whether those that are not submitted to the arbitrator can be resolved. Can the arbitrator include in his decision those matters that were not explicitly submitted to him for decision? And the answer is always, as a general rule, no. But as an exception, if it is closely intertwined. And second, in order to avoid multiplicity of suits. Kasi kung hindi niya desisyonan yan, magpapile na naman uli sila. And then, they will clog the docket of the court. They will also entail more expenses. And so, if the purpose of our legal system, going back to the Constitution, is to establish or to build a just and humane society, if the duty of the government is to serve the people, and the voluntary arbitrator is a private person, but he is performing a public function. He is the only private person who is allowed to exercise a public function, which is the administration of justice. Can you imagine that? Ang tanong na lang ngayon, kung mag-corrupt yung arbitrator, can he be charged before the ombudsman, considering that he is a private person? But I will not delve into that. That is an administrative law or political law. I will only limit myself with labor law. There are many other cases that I want to discuss, but it's almost 8 o'clock. This last one is a very simple one, that the negligence of the lawyer will bind the client. If the decision has become final and executory and management was not able to appeal because of the laziness of the lawyer, the client cannot escape and say, I will find another lawyer, please give me time to extend the time to appeal. No, you are bound by the negligence of your lawyer. No, that is the decision. So I think, ladies and gentlemen, although it's not yet 8 o'clock, but a few minutes, I will just stop here because I'm losing my voice, and I will now.
USEC.
Nawala, attorney.
Oo nga si Attorney Jimenez.
Number na nga siguro.
Nag-exit na.
Nag-exit na.
Exit. Sige.
Anyway, can we turn on our cameras and so that we can take a screenshot of our faces, please? By the way, thank you very much for joining us this evening. Hope we get to see you again next week. Okay. 1, 2, 3, smile.
Ay, musul balik si USEC.
Thank you.
Oh,
Pasod
musuod
na,
ba
pasod
si
na.
Yusek? Na si Yusek, na si Yusek.
I-accept sa call, please.
I-accept na ako.
Okay.
Admitted na si Yusek.
Attorney?
Patay ang wala pa-off ang video gang audio niya. Check na nato. Napa si Yusek.
Okay. Do you have any question
No question. Thank you, Yusek.
for those in San Beda? Please text your name so that I can record also the UE group. But for better efficiency, the middle means Evangelista and Jico, you take note of San Beda. And for the one in UE, if the middle is not here, you can just make your attendance known to me so that I can credit you for your attendance. I hope that you learn tonight.
Yes,
Yes, Yusek.
No?
Super.
Thank you,
Daghan kayo.
Yusek. Thank you, Yusek.
Thank you very much,
Nandiyan ka
Yusek.
pala.
Thank you po.
Thank you very much.
Thank you, Yusek.
Salamat. Picture muna tayo, picture.
Picture.
Picture Malik.
Open your, kahit yung mga guest, mag-open kayo.
Okay.
Papuri.
First three now. 1, 2, 3. Smile.
Udah kurang banget. Ya pasad.
Next screen.
Udah kurang banget.
3. Smile. Right. Thank you. Thank you, attorney.
Thank you,
Next
Yusek.
meeting, Monday. Anong date naman? Monday ba? Immaculate Conception?
Dili pa, attorney.
Tuesday,
So,
attorney,
Monday-
December 8.
Tuesday ang immaculate.
Okay,
Tuesday and
I will discuss all decisions written by Justice Marvick Leonid. So
Yusek.
please make a poster on decisions by Justice Marvick Leonid.
Sige po. Sige, attorney.
Thank you, Yusek.
Copy, attorney.
Okay.
Thank you, Doc.
Naka-picture na kayo?
Yes,
Mana-
attorney.
mana-
Done. Thank you.
Salamat.
Amping ka na Yusek.
Okay.
Thank
Dito ka sa.
Thank you so much.
Thank you. Thank you, everyone. See you next
Thank you,
week.
Yusek. Thank you, Attorney Wagan.
Thank you, Panyera. Shaya.
Thank you. Bye-bye.
Thank you.
Asa na ako pa mo Monday, ha? Ano day siya?
Thank you, Doc Cora.
Oh, you're thank you. Also, Attorney Waga. Adaw na sa ni Pauli. SRP na.
Amping, Doc.
Thank you, ma'am.
Take care, everyone. God bless.
Good night.
Bye-bye.
Teacher.